Our next panel, I'm really excited about hearing from. We have some space in our agenda for different reports that we felt would be important for people in the field to hear from on a regular basis. For instance, tomorrow you're going to hear a report from DOJ on the Uniform Language Project. Ted Hunt will be here to report on that. Later you're going to have a report from CSAFE about what they've been working on, what things they wish to let the field be aware of. And I think we would be woefully remiss if we didn't hear from OSAC on a regular basis about the work that they've been doing. And so we contacted John Paul Jones, the program manager, about doing that, and John Paul suggested that they had a full panel's worth of topic that they thought we would be very interested in hearing about. And when he presented it to me, I couldn't have agreed more. So this is really what officers of the court need to know. And so one of the things that I think is a struggle sometimes for attorneys in the field to get a handle on is, where can we get information of value to us about what's going on in the scientific community? And this is information that I think will help you in that regard. John Paul Jones II is the program manager for the Organization of Scientific Area Committees for Forensic Science, or OSAC, within the National Institute of Standards and Technology. OSAC is a federally funded program composed of 34 operating units involving 25 discipline-specific subcommittees. It provides national infrastructure for developing technically sound forensic science standards and implementing those standards across the forensic science industry. JP has more than 20 years of scientific and management experience in forensic science and the forensic science industry, including positions in the private sector and also with the Department of Justice and the Department of Defense. Also speaking today is Karen Reczek. Karen is a social scientist within the Standards Coordination Office of NIST, and she provides strategic and tactical support to the NIST-administered OSAC. She works with high-level federal, state, local, and private sector officials to coordinate standards development, to identify and support development of standard activities and programs to meet federal standards. She serves as NIST ex officio on the OSAC Committee for Forensic Science Standards Board, and she is the Vice President of the Society for Standards Professionals Board of Directors. She has over 22 years of experience in standards and conformity assessment activities and research. And finally, Judge Christopher Plourd is a judge on the Imperial County Superior Court in El Centro, California. In 2011, Judge Plourd was appointed to the bench by Governor Jerry Brown, and while in private practice, he was recognized as an expert in forensic evidence, crime labs, and DNA testing. He is the longtime chair of the Legal Resources Committee of OSAC. Please welcome our panel.
Thank you, Matt. So yeah, I'm JP. It's great to be here. And boy, you guys are in for a treat. Standards. Wow, how exciting, right? After lunch, too. So yeah, we're really excited. I'm going to introduce the panel. Then we're going to let Karen go, and then I'll go, and then Chris Plourd will go. But we're really excited to be here to work with the ABA and with Matt Riedel when we were talking to him about putting this together. Because we're actually hoping to encourage the adoption of OSAC-recognized standards by the entire criminal justice system, so the crime laboratories and the officers of the court. And we're all in the same criminal justice system. We play different bits, but we're promoting the adoption of the standards that we recognize through the entire criminal justice system. And that's in keeping with the continuous improvement of the practice of forensic science in the U.S. So that's really what OSAC is trying to do. And today we put together a panel where we thought we'd walk through the entire landscape of forensic science standards that are out there, from the ISO to the Astm and a variety of other things that Karen's going to go through. I'm going to talk a little bit after that about what OSAC is doing with these standards and how we're trying to evaluate them and make them more visible and encourage specific adoption of specific standards. And then the dessert on this whole thing, from my perspective, is Chris Plourd talking about the actual use of some of these standards in the courtroom and how they had an impact on specific cases. And so I wanted to note, so we have one judge on the panel, and I tell you, if I was a judge, I'd walk around in my robe all the time, just so everyone would know I was a judge. The judge left his suit jacket in, I guess, the previous place that he was before here, so he's got his coat on, but not his robe. So that's too bad, but that's all right. He still has a very important thing to say, even without the robe. So with that, Karen, please go on.
Look at you, didn't even use your slides.
Oh, yeah, sorry. Go ahead and page down.
I will. Good afternoon. It's a pleasure to be here. I know you're very familiar with standards in the ABA land, but the focus of my talk is documentary standards. And I'm hoping by the time I'm done, you'll have a real good sense of the tremendous activity and the enormous progress that's being made in forensic science standards development. So I thought I'd give you a little grounding on what is, in documentary standards, what we consider to be a standard. I chose, oh, mine's cut off. Interesting. I source it, so it does have the source. The source of these definitions come from the National Technology Transfer Advancement Act and the Office of Management and Budget A119. It's a circular. And we describe standards as having a common and repeated use of rules, conditions, and guidelines or characteristics for products or related processes or production methods. So you can see how that would apply to forensics. Same thing with the next, definition of terms, classification of components, specifications, dimensions. We've got test methods, sampling procedures. So these are all what we consider standards. I'm sure that everyone has a phone, and you're all familiar with the millions of standards that must go into actually making that interoperable. So in the U.S. standards world is very different than the rest of the countries around the world. So a lot of the other countries just have one national standards body. In our country, it's very different. So the first is standards are voluntary. What that means is people choose to use them. They're not mandated by any laws unless they're incorporated by reference. So there are some agencies like the Consumer Product Safety Commission that's incorporated several standards into their regulations, which makes them mandatory. But in general, standards are voluntary. We have a decentralized system, so that means that we have many, many standards developing organizations. There are over 600 standards developing organizations in the U.S. It's sector and market driven, so basically it's the industry that drives the development of these standards, not the regulatory world. And sometimes it's competitive and duplicative. So what that means is we have so many competing SDOs, they could be putting out the same standards on the same topics, and they may not have the same content. They may be overlapping, or they may be completely contrary to each other. It's also competitive because in U.S. standards development is a business model. Most standards making bodies sell their standards, so they actually get money from that. They have to support the infrastructure, so it also becomes very competitive from that standpoint. But it relies on a lot of different things, and cooperation is key. There are a lot of different players, generally the industry players. In the case of forensics, that would be the labs, private sector standards bodies, those are the SDOs, stakeholders such as yourself, lawyers, nonprofit organizations, consumer advocacy organizations, organizations like the Innocence Project, and the government. Obviously, a lot of government agencies are stakeholders in this as well. So I wanted to talk to you about the federal policy on standards, sort of near and dear to my heart, working at NIST. The National Technology Transfer Advancement Act and the OMB Circular A1119 says that there is a preference for federal agencies to use voluntary consensus standards over creating unique government standards. So what they want you to do is to look to the private sector standards developing organizations first before you go and develop your own agency-specific standards. If it doesn't meet your need, then you're free to go ahead and develop those government unique standards, but they really want to push that focus on using voluntary consensus standards. Also encourages every federal agency to have their employees participate in standards development. So it's actually written into people's objectives. It's also many policies in many agencies that people participate and are at the table. And it also authorizes NIST to basically hopefully coordinate the assessment of these activities with the different federal agencies and to work with the government and the private sector to sort of work to develop voluntary consensus standards. So some key concepts. This is sort of across the board. It doesn't matter what standards developing organization you're in. One is openness. It needs to be open to everyone. Everybody is invited to the table. Nobody can be excluded. So if you are Joe Public citizen and you want to come to the table, you can come to the table. The key here is that they don't want to have any dominant interests. So there's a lot of rules about lack of dominant interests. So no one single, what we call interest category, can dominate the number of people on a committee. Transparency means everything should be as open and transparent as possible. All your records, all your procedures, all your processes, all those ballots could be as available to the public. Due process basically means that there are procedures in place. There's a process for appeals. Due process often is what makes standards development very slow. And consensus. So this is the absolute hardest part of standards development, is reaching consensus. It's a very difficult thing, and it's very slow. What it means is that it has to be a majority decision. It doesn't have to be unanimous. What we usually like to try to say is it means that you can live with it, right? You may not love it, but as long as everybody can kind of live with it, we can move on. This is a view of what the standards development life cycle looks like. So at the very far right, you have where we initiate the project. You get a working group together. Sometimes it's called a technical committee or a working committee or a consensus body. They draft that standard, and then they send it out for ballot. Then everybody has to ballot. If it doesn't pass the ballot, it has to go back. They have to resolve negatives. They have to find them either persuasive or non-persuasive. If they find them non-persuasive, they have to adjudicate why they found them non-persuasive. And finally, when they gain final approval, the standard is published. But it doesn't stop, because the minute it's published, they start back to revising and maintaining the standard. Most standards developing organizations have a rule that you have to revise your standards within a 5-year process. If you don't, it's withdrawn. But there are many standards bodies that will actually initiate new work items immediately. We can find that minute it gets published, you can institute a new work item to make a change. So you don't have to wait 5 years, but there is a requirement for 5 years. So I'm going to talk to you specifically about the ones that are in the forensic space. So what I have done in your packet that you would have gotten ahead is I have provided you with a 38-page handout that lists every standard known to mankind that we're aware of on forensics. I didn't include the Chinese ones because nobody can read them there in Chinese. So I wanted you to know the minute this was published, it was out of date. So I've got to accept the fact that it's a constantly changing process. I'm going to give credit to my colleague, Teresa Ambrosius, and she's at the American Academy of Forensic Science Standards Board because she helped compile the stuff on ASB. Each of these things that I cover here has more information. So I've talked to you about also how many voting members they have. I've also indicated the leadership, so I'm not going to go over all of that now. I'm just going to kind of highlight some of that. And also, just to give a good plug to OSAC, if there was a standard on this list that's on the OSAC registry, there's a little symbol next to it that shows that it's an OSAC registry standard. So let's go through these. So we heard from Ken earlier. The American Academy set up a standards board. And basically, they are really dedicated to specifically working in forensic science. They have been basically the place where most of OSAC standards have been going, but not all. So they get almost every single work product they have to date has come from the OSAC. It is a wholly owned subsidiary, and it was established in 2015. And it is accredited by the American National Standards Institute. Now, what does that mean? So if you are an ANSI accredited SEO, you're accredited to the ANSI requirements, due process requirements for publishing an American National Standard. What does that mean? So American National Standard is a special designation, and it means that you publish all of your items, whether you're entering a new work item, into their publication called ANSI Standards Action. That means everybody out there can see that you're instituting a new work item. And if you have a competing item already, you can comment and say, hey, we've already got an item like that on our books, and we want to kind of resolve that. Then when you publish a draft standard, they announce that the draft standard is out there, and anybody can comment on that standard. So they recently published a toxicology standard draft. They got 175 comments from the public on that standard, and they had to resolve them. And they actually said when they were done, they felt they had a better standard based on all of those comments. So that's what the ANSI process does. It's full disclosure. It's absolutely 100% open and transparent. And ASB has made the commitment to publish every single standard as an American National Standard. The other thing that they've done is they are partially funded by a grant from the Laurel and John Arnold Foundation. So they have often made a commitment to make all of their standards available for free. This is sort of unheard of in standards land, but all of their standards are available as published on their website for free. So they have 13 consensus bodies, and I'm going to show you what they are here. So as you see, we get into this, we're getting very discipline specific, a very deep dive into the different kinds of standards that can be developed for these different areas. I have given you the handout for ASB. Anything bolded means that it's a published standard, and then everything else are work items that are in development. I'm not going to talk to you about ASTM International. It's an incredibly old standards developing organization, been around for 120 years. They deal with all kinds of things. I have to say their origins were in materials and manufacturing, so that's a lot of their technical committees. But they do have a very large membership, and it's also international in scope. It is one of the few SDOs that require you pay a fee, not an earth-shattering fee, but you can become a member for $75. You can join as many committees as you want. And you can also get the standards for all the committees you belong to for free. So they have a committee called E30, which is on forensic science. It was formed in the 1970s. Really was the first ever U.S. standards developing organization working in forensics. And this is their scope. I'm not going to read it to you. We didn't know they were all going to cut off. They looked fine when I saw them. So E30 has over 560 members, and they have 4 different subcommittees that I'm going to highlight. So in criminalistics, they're dealing with things like trace, fire debris, seized drugs. Those are the areas that they're covering, a lot of the materials. What was that? And then interdisciplinary is their little broader one. So in here we have things like labeling of evidence. We have some stuff on reporting. And some of the actual sexual assault standards have been put in here, but they're going to get moved, we believe, to criminalistics. And we know that our crime scene at OSAC is going to start sending their standards to ASTM, and they're going to be put into the interdisciplinary category. Obviously, the digital multimedia is exactly what it is. It's all the standards to deal with digital multimedia evidence. And then E32 is a specifically a committee that manages terminology. And actually, we have its chair right here in the room, Jack Mario. What was earth-shattering for E3092 this year is they actually passed a new ballot to take a new standard, to take their basic terminology standard and add every single term referenced in every single ASTM E30 standard and put it into the master standard. So you can now find all the terms used in all the forensic science standards. And what's the number, Jack? 1792? E1792? Yes, so it's ASTM E1792. So that's really, that's a big thing. So the other thing with ASTM is that the committee has been working towards publishing American National Standards as well. So we did go out for a ballot, and it has come back with just a couple negatives that we're going to resolve. So should we be able to resolve that, then probably early next year, ASTM will start publishing their standards as American National Standards, which means they will be open for public comment and input as new work items and as drafts are available. One other comment on ASTM. OSAC has licensed with ASTM International access to the forensic science community for everybody except for the private sector. So if you're a private sector lawyer, I'm sorry, you're not allowed. But it's to make the barrier of getting these the cost of standards not a barrier anymore. So they are available, a link through the OSAC website that you can access all the E30 forensic science standards. I wanted to mention ADA, very niche, very small. They basically have two standards out there. One's on dental set and one's on sort of human identification comparison. No bite mark standard yet that we're aware of, so hopefully there won't be one soon. I do want to mention ISO. We hear a lot about 17025 and 17020. ISO is an international organization, very different than the US model in that it's country participation. So every country has a seat at the table. 163 different countries participate, and they have thousands and thousands and thousands of standards and lots of technical committees. So a couple of years ago, I think it's about 4 years old, ISO formed a technical committee, TC 272, on forensic sciences, and this is their scope, and you can't see at all. The secretariat right now is Australia, and she holds that chair through 2020. TC 272 actually just met in the US in conjunction with the ASCLD Symposium in St. Louis. I think we had 15 countries participating, so it was quite an interesting meeting. So at this point, there are actually 24 participating member countries. In ISO, you can either be observing or participating. If you observe, you don't get a vote. As I said, we had 15 in 15 in participation in our recent meeting. They have 3 published standards. One is actually on DNA contamination of consumables. So if you have consumables for DNA test kits, that was the first one published. The other ones are a 5-part series, very high-level framework documents. They're ISO 21043. There's -1, 2, 3, and 4. So part 1 is terminology, and what happens is as the parts are published, the terms from that will go into part 1. So right now it's very skimpy, but as the other parts are published, they'll get added to. So part 2 is a published standard, and it's basically, if I had to simplify, it's on the collection and preserving of evidence at a crime scene. And so the third part is on analysis, and part 4 is on interpretation, and part 5 is on reporting. So we are working very hard on getting those standards through several drafts, and I expect they'll be published in the next couple of years. I do want to mention that ASCLD has stepped up. They have what's called a mirror committee. For every country has their sort of own little committee. It's called a technical advisory group, and ASCLD is the secretariat for that mirror committee, and I've listed the chair. I did want to mention the ISO IEC Joint Technical Committee. It's called JTC1. They have a subcommittee on biometrics because I think it's completely relevant to this group. If you look at the document, literally hundreds of standards, but some of them are incredibly relevant to this field. I'll just show you a little bit about them. They've got 121 published standards, lots of them in development. Some are specific, obviously, on biometric stuff. Some are actually broader on speaker recognition and even digital evidence. So the last one I wanted to mention is NFPA, also very niche-y, but they've been around a very, very long time, just like ASTM. Lots of members, lots of volunteers, and the specific ones that we're concerned about are the Fire Investigation Technical Committee. They have 2 documents that are very voluminous and pretty much the Bible in the fire investigation world. One's on the qualifications of fire investigators, and the other is basically on fire investigation. They are starting a new one that is in development that's coming out through the OSAC. So that's all I'm going to tell you about standards, but I would recommend that you take a look at the handout, and I'm going to turn it over to JP.
All right, thank you, Karen. Okay, so I'm going to talk a little bit about OSAC and what we're actually doing with some of these standards, the role that we play in the standards development system, and then again, we'll pass it on to Chris to talk about the use in court. So the part of my talk is going to have a slight introduction for those of you that aren't aware of what OSAC is, talk about this registry, which is the aspect that we're marketing across the country that labs should adopt, and describe a little bit more about our document tiers, and then staying connected, how you can stay aware of what's being placed on the registry, what's open for public comment, and those kind of things. So it was interesting when I heard the discussion earlier today on the competence to proceed panel, where they were talking about psychiatry and the challenges with consistency across the country, even states and localities having different ways of addressing things, it actually made me think of this slide that I have in in my deck here about the forensic science landscape in the United States is very complex. And the statistics here we have are from the DOJ's Bureau of Justice Statistics. And so there's 409 crime labs in the U.S., 88% are accredited. This is the 2014 from the census that used the data from 2014. We have 18,000 law enforcement agencies, 2,400 ME coroners, 2,300 prosecutors' offices, and 3,000 public defender offices. With a population of 327 million folks in 50 states further divided into counties. In the United States, we have no forensic science owner. So there's no one that snaps their fingers or issues a resolution that says all parties must do X. That doesn't exist. Even the federal folks, the Department of Justice, as you heard, and Ted, I'm sure we'll talk about this tomorrow, they can help enforce particular aspects in their laboratories, the laboratories that are part of the U.S. Department of Justice. So the alters, that I assume he'll talk about tomorrow, they can make their laboratories use those particular documents because they oversee them. But there's no one else that oversees the forensic science landscape, and the vast majority of forensic science business is done at the state and local level. So it's a pretty interesting dynamic to get into. So for us, the OSAC, we're basically a diverse group with researchers, academics, and lots of practitioners, 550 folks, and we actually are trying to increase the use of standards in the forensic science domain. So we're looking at both the technical rigor of the documents and how they were made, through what kind of consensus process. So we were launched in 2014. We started operating in January of 2015, and we're a federally funded program. So this is a snapshot of the OSAC itself. So around the outside, there's 25 what appear to be lollipops. Those are the little circles. Those are our discipline-specific subcommittees. And their role is to help develop standards that are specific for that domain. And so we have firearms, fingerprints, or friction ridge as we refer to it, all kinds of other disciplines. We have 2 DNA subcommittees because everyone knows that DNA is special. And there's the analysis, the biology you do, and then there is the interpretation of the results. So those are in 2 different subcommittees. But then we get into things where there are cross-disciplinary activities, and those flow up into our biology scientific area committee, our chemistry, or our physics or crime scene. So when things are cross-disciplinary, they start flowing up so we can have a cross-disciplinary place to work on those particular items. And so we have a fair number of academics and state and locals on this particular, in the OSAC, and this changes yearly. Our rosters get re-upped every October 1st. We have significant membership changes that occur during that time period. And so we have 56% of the practitioners across the entire OSAC, and we do have some attorneys and judges and researchers as well. So there's really 2 things that OSAC does, and if you leave this presentation today, other than knowing the landscape of thousands of standards, hundreds, I exaggerated there, hundreds of standards that Karen referred to, the 2 things that we do in OSAC are we evaluate the existing standards that have been published by an STO to determine if they should be placed on our registry, which means we basically endorse that standard. That's one activity. The second is if a standard does not exist that meets the needs of OSAC, they will write that standard or a draft version of that standard and introduce it into an STO for formal standards development. Once it's published, then they will evaluate placing it on the registry. Those are the 2 main things that we do in OSAC, and they both take lots of time. So for us, the registry is our trusted repository, and this is where we isolate down to the ones that have been evaluated and that we believe, the OSAC believes, that folks should adopt. And again, they're evaluated for both technical merit and on the consensus-based processes that was used to build that standard. So our endorsement is the highest level of recognition we can provide to standard. So right now we have 15 documents on our registry, and I know this is kind of small there, but we have a facial identification standard, then we have 2 from the National Fire Protection Association, which are pretty common for their investigative field. They both determine the qualifications that someone should have for being a fire investigator, and how they should investigate fires. We have 5 standards under a materials trace domain, or forensic science discipline, dealing with paint and glass, and a few of those are test methods. But the interesting thing about trace, as many of you know, is that it's not as widely practiced of a discipline as it used to be. It's a very expensive discipline, and not all laboratories have these capabilities. We have 2 odontology standards that were published by the American Dental Association that are placed on the registry. Most of those, the content of those are dealing with dental identification for decedents and things like that. And as Karen referenced, there is no bite mark standard on the odontology, under the odontology section here. Our seized drugs subcommittee there are 2 standards that are listed on there. The one of interest, which will be referred to later today, E2329, is a standard practice for the identification of seized drugs. And the interesting thing about this standard, this would be actually the second takeaway, because I'm going to talk about it now, and Chris is going to follow it up. This standard design outlines a scheme that should be followed when you're identifying particular drugs. It does not allow for a laboratory or an individual to make a conclusive identification using a single color change test. So if you have a field kit that you perform, it changes colors with the indication of some kind of drug, this standard says that should not be used to make a conclusive identification. So that's an important takeaway if you weren't aware of that already. We have a few interdisciplinary standards on there as well, for ISO 17020 and 25, and then there's one data transmission standard that's there. So other than those 15 standards on the registry, we have a lot in the pipeline, and we've sort of divided it up into multiple tiers. We have 20 documents that OSAC has drafted within the organization, sent to SDOs, and they've been published. So those we are hoping will enter the registry approval process for us to elevate to the registry. We have about 75 other documents that OSAC has written, and that particular subcommittee has endorsed it and wants the community of practice to follow it. They've posted it on their website and sent it to an SDO for formal standards development. So we believe those 75 documents, those are ripe for people to start putting into practice or to consider putting into their laboratory's practice. They're a reflection of the subcommittee's support of that particular discipline, and they are being introduced to be formally developed in an SDO. And then we have several hundred documents in development at this point. So I wanted to just show an example of a friction ridge standard that is on our website right now. It's also in the packet. This is one that the packet that you can download. This is a standard for friction ridge examination conclusions that our subcommittee, our friction ridge subcommittee, drafted. And it went through a variety of reviews with human factors and legal, and it's been put up on our website and sent to the Academy Standards Board that Karen referred to earlier for formal standards development. So this particular standard does something different than what traditional forensics friction ridge conclusions have. It introduces the concept of support for different sources and like an intermediary between exclusion and inconclusive. So it has really a 5-tier standard, 5-tier conclusion. And in addition to that, so it has the support for same source conclusion and then source identification. So there's really 5 tiers here rather than the standard 3 that have been used in the past. And in addition, this particular document has some qualifications and limitations in it that says that the examiner should not assert that a source identification is the conclusion that 2 impressions were made by the same source or imply an individualization to the exclusions of all other sources. And it has a few other points in there which are, I believe, been widely discussed in this legal environment. The examiner should not suggest that the offered conclusion is an expression of absolute certainty on their friction ridge conclusion. They should not assert or imply the latent print examination is infallible or has a 0 error rate. And they should not cite the number of latent print comparisons performed in his or her career as a measure of the accuracy of a conclusion offered in the case at hand. And they should shall not use the expression reasonable degree of scientific certainty, as we heard earlier today, or similar assertions as a description of the confidence held in his or her conclusion. So some of these documents, if you're approaching a friction ridge case, there's at least some useful tools here that folks could use to see if the examiner you're working with, either on your side or opposing counsel side, is testifying within the limits of what the discipline is considered appropriate. As Karen mentioned, the government has set up access for public defenders, prosecutors, medical examiners for free access to ASTM E30 standards through the OSAC website, and so that will not be a limitation for getting access to those standards. So we have a monthly standards bulletin that we put out that announces all the new standards that are placed on our registry. The ones that it also describes the open comment period. So if OSAC is considering putting a standard on the registry, we seek open or public comments on whether it should be placed up there or not. And we're also tracking all the standards as they go through SDOs, their open comment periods, and what new drafts are indicated that have been introduced. So this is really a quick way of figuring out what the latest in the standards landscape is each month. So you could have someone in your office, assign them to just do a quick scan of this to see if there's anything that's relevant for you, especially if you handle a lot of a specific type of cases, firearms or question documents. And the other thing I wanted to note as well is that the ASB currently has a standard open for public comment right now called the Best Practice Recommendation for Articulating a Source Identification in Friction Ridge Examinations. And this is open on the ASB's website until July 8th to seek comments on, do folks like it? Should there be upgrades made to it? Any changes? And it has lots of information here. There's really 9 different steps that they talk about what an examiner in the friction ridge arena should do. It goes into when they're making conclusions. It talks about the friction ridge skin contains persistent morphological features that can be highly discriminating. But it also describes in here some of the limitations, such as while the highly discriminating nature of friction ridge skin is often expressed as uniqueness, this claim has not been empirically proven. So it has useful information in here that might be helpful if you're approaching a friction ridge case and you want to use what would be considered the standard of practice for that community. So there's a whole lot of information out there, and what OSAC is trying to do is to really bring it down to the level of what do you need, what is a good standard to follow, and make that available to folks. And so our website's really cut up into 25 different domains. So if you have a DNA case or something like that, we have a website for each one of those, and you can see what standards they've either produced or in production or drafts that are on their way, which might be helpful for you with your future cases. And I think that's it. So now we'll have Chris Plourd come talk about where the rubber meets the road.
All right. And the rubber does meet the road. It meets the road in our courtrooms and in our litigation and so forth. And I feel that we're at the right place. And if you ever need an expert, go to the OSAC website, go to your particular area, look at the people that are on the subcommittee, and just call one of those people, and you'll get one of the better experts that you can find. So we all know what the focus is on forensic science these days with the various reports and studies and so forth. There are a lot of different people that are looking at forensics and evaluating it, and you know, they've got some historical problems with it. But basically, I think one of the main drivers is actually statisticians are looking at forensics, and they're trying to basically demonstrate the problems that some of the conclusions that are being testified to present. So you should educate and learn you know, about that. This is a quote from a journal I subscribe to, the Science Journal, about statisticians are on a mission to reverse a legacy of junk science in the courtroom. And if you ever want to know where junk science is, it's always in the courtroom, because that's where it plays out. It depends on whose ox is being gored, but there's always something for everybody. I'm going to talk particularly about standards and how they're being utilized in courts. This case ended up in my court. It involved a prison drug seizure and so forth. And in prison, drugs are very coveted. They go for 2 or 3 times the price. One of the problems with prosecuting those cases, though, is that sometimes prisoners, not being the totally honest persons that one would expect, they sell bunk drugs. So it's very critical to know whether they're selling something that's not a drug versus something that is. You know, on the street, you know, we have actually almost like consumer protection. You know, the word of mouth gets around, and some drug dealer just isn't going to have a lot of business if he's selling non-refined drug. But in prison, hey, that's just the way it goes. So in our county, we have 2 prisons, and they charge people with crimes, either assaults or drug cases or whatever cases that come out of prisons. They charge them by a grand jury, a criminal grand jury. And essentially, they've been doing this for 20 years or so. And what they do with the grand jury indictments is they have the officers testify to the results of a NIC test, or a colorimetric type test. These are commercially available. They're used all around the world, et cetera, et cetera. One company actually has most of the market over the years. Apparently this company, according to the testimony that was presented, has bought out all the other companies. They call them different things. NARC2, they have a number of different names, but the most popular one is the NIC test, and they test for a variety of different controlled substances. Essentially what they do is you put a little bit of the suspected drug in a pouch, and you may have to put it in a series of pouches if you don't know what type of drug it is. And then if it turns a color, in this case they make it rather simple. They print heroin on the outside of the package, and they put green. If it turns green, then it's heroin, and they come to court and they actually testify in front of a grand jury that I tested this and it came back as heroin. So this was done according to the manufacturer's instructions and so forth. They have a name for the way that they can go through and evaluate different possible drugs and eliminate certain ones and eventually come to the one, and they have a thing called their identidrug chart, and the expert, who is now the correctional officer, who gets 4 hours of training, by another correctional officer who gets 8 hours of training because he's the master trainer, and so forth. And so they become their drug experts in front of the grand jury, which of course doesn't get much scrutiny by way of cross-examination or whatever, as the testimony would be. This is a picture of the pouch that was involved in the litigation that was in my court, and the device loader, which is a pre-designed little thing where they put a little bit of the drug in the area, in a little area of the end of that, and they put it into the pouch. That's their measurement device so that they get a pre-measured amount. It doesn't matter what the drug is or where it comes from, what the purity is or whatever, the same amount goes in the pouch. Then they read the instructions on use. In this particular case, they had the L test. It's called the modified Mecki reagent, and it tests for heroin, including white, black, or ecstasy, etc. And if it turns purple, it's MDMA. If it turns green after breaking a second ampule, after they prolongedly agitated, if it morphs towards green, then it is identified as heroin. So in any event, the local attorneys finally got the idea that maybe this test wasn't scientifically acceptable. And in California, grand jury testimony has to be trial admissible. In other words, there's no lower standard. In some states, different tests can be utilized in preliminary hearings or other lesser hearings, administrative hearings, and it doesn't have to be admissible at a trial. But in California, by statute, any scientific evidence admitted before a grand jury has to be admissible at trial. So this litigation went on for a number, almost a whole year over a period of time, because I had 6 lawyers, and to get them all together on the same day took for only 5 to 10 times, but it took over a year to get that done. But it involved 2 standards. One was an Astm standard regarding seized drugs, and the other one was an ISO standard that got some play during the course of the litigation and so forth. The ASTM standard, as JP mentioned, essentially said was a minimal testing requirement standard, saying if you're going to identify a drug, you have to do certain things. You either have to do a category A test and a B test and so forth, and you cannot just do one test. You have to, in order to have some confidence in the outcome, and it lists this out in exquisite detail as to what tests that you can and cannot use. Color tests are included in there, but they're considered a very low-level test, and they basically say you cannot make an identification based upon a low-level test, including a color test. And essentially, this is what was being done in these prison litigation cases. Now, 2 prisons, you can imagine, we're getting, in our county alone, we're getting 10, 20, 30 of these cases a month, and they've been doing this for 20 years. So this was a monumental issue that came, during this litigation. We had 4 or 5 people that were actually consolidated in a kind of a scientific challenge regarding the colorimetric test at issue, the NIC test, and there were about 100 cases that were waiting for this decision or this hearing to finally conclude. And it all revolved around whether or not these tests were scientifically reliable. So the Census drug standard was essentially litigated in the context of our California statutes and laws and so forth, and there actually are a number of cases, both in California and otherwise, that they refer to ASTM standards and use in litigation and so forth. They're referenced in our case law. In California, we don't have the Daubert standard. We have a Kelly-Fry standard, and we also have a case by the name of Sargon, which is similar to a Daubert requirement. It's where it tells the trial courts that they have to act as gatekeepers and so forth. So the attorneys, started this hearing, challenged this, and a number of them got together and so forth. I put together a pretrial order basically saying these are going to be the issues. I required that if they're going to file any peer-reviewed or any scientific publications, that they have to be peer-reviewed and they have to be consistent with the views of the commission regarding scientific literature. I felt that was a minimum requirement. Now, even though I did a pretrial order, that didn't stop them. They still filed all kinds of publications that weren't scientifically acceptable. But as it came through during the litigation, all these standards became exhibits. They got referred to in the briefing, and essentially both sides didn't have any objection to them. The prosecution and the defense, they just agreed. These are published documents. It's almost like they're published literature and so forth. And so they all came in without objection, were referred to extensively by the witnesses. And the lawyers got very adept at taking the standards and parsing them out, depending upon whose ox was being gored. And they say, well, do you do this? Do you do that? If you don't use a particular standard, well, then what standard do you use? Like, for example, the prosecution expert from the California Department of Justice, they don't use ASTM, the ASTM standard. They have an ISO standard, and they compared the two, said, well, the ISO standard and our requirements are actually higher than the minimum ASTM standard. So they were able to, at least the defense was able to leverage that and say, well, look, they even do something even more rigorous and so forth, and they don't agree with the the color testing conclusions and so forth. So after thousands of pages of 112 exhibits, then we finally get final briefing on the case, and they extensively used the evidentiary standards or the standards that were put in evidence in arguing their case one way or the other. Both sides say, well, this isn't done, this isn't, this is done for this reason, this doesn't meet this ASTM requirement from this particular standard. They reference the transcripts that were produced as a result of this hearing and so forth, and exhibit numbers and so forth, and it was just a key way for them to get their point made to the court, eventually, getting a decision made and what have you and so forth. So they talk about, the ASTM standards regarding validation, what it takes to validate, how things get done and so forth. So it was an interesting aspect of sort of where the rubber meets the road. How do these standards really get used, in our criminal justice system? And I think it's catching on. I do a lot of judicial education, and standards come up, and a lot of questions are being asked. Courts tend to like standards because it helps them, sort of get to where they want to go. When you look at a judge and you ask him where he wants to go, he wants to get the case over with, move on so they can go do something else. And standards are like a case on point. If they deal with a particular subject or issue, they can look at that, take it for what it is, and then move to the next subject. I gave a talk about 6 months ago to the appellate justices and the justices on the California Supreme Court, and one of the issues that came up was civil litigation as it relates to standards and so forth. And one comment that one of the justices on our California Supreme Court noted is that in the context of litigation, particularly civil litigation, standards are being used to prove or disprove the issue of insurance bad faith, for example, in fire litigation. And he used the example of the NFPA standard. If some insurance company hires a fire investigator that's not properly qualified, and that investigator denies coverage based upon his investigation, and then the claimant says, look, I didn't get paid for my covered claim, and you hired an incompetent investigator, they can use the standard to prove bad faith, get, you know, to basically jumpstart and litigate against the insurance company. So I think standards are here to stay, and I think standards are going to be coming to our courts more often as they get utilized and get developed during the forensic science process now that we're using them. And the forensic science community is going to embrace them more when they see them used in court and so forth. There was one example of an attorney was cross-examining a fire investigator who was not well qualified, local, typical person that worked at a fire department. He was an arson investigator, and he used the standard. And after a few minutes, the investigator, who was not past any type of proficiency, didn't meet the fire investigator standard at all. He started sweating and so forth, and by the end of the cross-examination, it looked like an emulation. He was just burning on the witness stand because he didn't meet any of the criteria that the standard actually set forth and so forth. So with that, I think we're pretty much done. You may wonder why I like coming and talking about standards.
What happened to the drug cases? Did you throw them all out?
The decision is in your case material, and yes, I did. In the end, it all came out for a number of reasons, in addition to the scientific issues and so forth.
Thank you.
All right. So, in any event,
We actually have time for.
Oh.
all right. You may wonder why I like to talk about standards. You know, that's because I live in a rural community. My court is on the border in California, about 2 miles away from the wall, and we are a farming community, and the usual crime that we see are either the most serious crimes, or we get like the local farmer gets his goats stolen, and essentially that comes into court and so forth. So, okay, with that, questions, I guess, is the next. Okay, come on. A lot of case materials, and I put the briefing in there, some of the transcripts, and so it's hard to really get you to understand all the detail unless you read it through and so forth. And then the decision, which kind of summarizes everything and so forth. So, all right, thank you much.